media. Today we are going to talk about the new controversy that is going on in India, and that is the sedition law and its turmoil in India. The Supreme Court on Wednesday directed the centre and states to keep in abeyance all pending trials, appeals and proceedings with respect to the charge framed under Section 124A of the Indian Penal Code, which deals with the offence of sedition, till the central government completes the promised exercise to reconsider and re-examine the provision. The central government had initially defended the colonial provision, but later told the Apex Court it was reviewing it. Well, what is the sedition law here? Section 124A defines sedition as whoever by words, either spoken or written, or by signs, or by visible representation, or otherwise brings or attempts to bring into hatred or contempt, or excites or attempts to excite disaffection towards the government established by law, shall be punished with imprisonment for life, to which fine may be added. Well, the provision also contains three explanations. Here are the explanations. The first, the expression disaffection includes disloyalty and all feelings of enmity. Second, comments expressing disapprobation of the measures of the government with a view to obtain their alteration by the lawful means without exciting or attempting to excite hatred, contempt or disaffection do not constitute an offence under this section. Now the third, comments expressing disapprobation of the administrative or other action of the government without exciting or attempting to excite hatred, contempt or disaffection do not constitute an offence under this section. So what are the origins of the sedition law? Although Thomas McCulloch, who drafted the Indian Penal Code, had included the law on sedition, it was not added in the code enacted in 1860. Legal experts believe this omission was accidental. In 1890, sedition was included as an offence under the Section 124A IPC through the Special Act 70. The punishment prescribed then, transportation beyond the seas for the term of his or her natural life, was amended to life imprisonment in 1955. Well, the provisions was extensively used to curb political dissent during the independence movement. Well, several pre-independence cases involving Section 124A of the IPC are again celebrated freedom fighters, including Bal Gangadhar Tilak, Annie Besant, Shaukat and Muhammad Ali, Maulana Azad and Mahatma Gandhi. Well, it is during this period of time that the most notable trial on sedition, that was Queen Empress versus Bal Gangadhar Tilak, that took place in 1898. Well, courts largely followed a literal interpretation of the provision, holding that the disapprobation must be compatible with a disposition to render obedience to the lawful authority of the government and to support the lawful authority of the government against unlawful attempts to subvert or resist the authority. Well, the Constituent Assembly debated including sedition as an exception to the fundamental right to freedom of speech and expression guaranteed in the Constitution, but several members vehemently disagreed and the word is not included in the document. Now, here are the legal challenges to the IPC Section 124A. As early as 1950, the Supreme Court in Ramesh Thapar versus State of Madras held that criticism of the government exciting disaffection or bad feelings towards it is not to be regarded as a justifying ground for restricting the freedom of expression and of press unless it is such as to undermine the security of or tend to overthrow the state. Justice Patanjali Shastri cited the Constituent Assembly's deliberated omission of the word sedition from the Constitution for the liberal reading of the law. Well, subsequently, two high courts, the Punjab and Haryana High Court in Tara Singh Gopi Chand versus the state in 1951 and the Allahabad High Court in Ram Nandan versus state of Uttar Pradesh in 1959, declared that Section 124A of the IPC was primarily a tool for the colonial masters to quell discontent in the country and declare the provision unconstitutional. However, in 1962, the issue came up before the Supreme Court in Kedarnath Singh versus State of Bihar. Well, this was all about the sedition row that is going on in India right now. Stay with us, we shall bring you more such important topics to talk upon. This is Aparna Singh reporting for iScope Media.